She walked into that hearing room carrying a binder, not a legal brief, not evidence. A binder she called out loud, on camera, in front of the survivors sitting directly behind her. A burn book. If you don't know what a burn book is, it's a prop from a teenage movie about high school girls destroying each other's reputations. The Attorney General of the United States brought that to an oversight hearing about the largest child sex trafficking network ever prosecuted on American soil, waved it at a congressman, and asked him to pick his best shot. That moment was a calculation, and it tells you more about the state of the Department of Justice right now than anything else said in that room. Jared Moskowitz is not who you'd expect to walk into a hearing with the most ammunition. He represents a Florida district. He went to Marjory Stoneman Douglas, the school where 17 people were killed in one of the worst mass shootings in American history. He co-authored the largest legislative response to a school shooting this country has ever produced, working alongside Pam Bondi when she was Florida's Attorney General. He thanked her for that at the start of his time. He acknowledged that her department had prosecuted a man who had targeted him personally. 2 rifles, a silencer, 3,000 rounds of ammunition, an anti-Semitic manifesto, his name the only one on the list. His kids found out from their friends at school. He thanked her. And then he opened a different folder, the kind that ends careers. He started with Kash Patel. Under oath, Patel told Senator Kennedy that Trump's name appears fewer than 100 times in the Epstein files. Moskowitz then entered into the congressional record what the actual count shows. Trump's name appears more times in those files than God's name appears in the Bible. More times than Harry Potter's name appears across all 7 books written about him. Those are the verified metrics. But according to sources familiar with the committee's ongoing review, sources whose accounts have not been independently confirmed, the actual figure may be significantly higher than what has been publicly disclosed. These same sources suggest that among the appearances are references connected not just to social interactions, but to specific events, specific locations, and specific individuals whose identities remain redacted. What has been confirmed is that Patel's claim is demonstrably false. A name does not appear in a federal criminal file at that frequency unless it is central to what was being investigated. Now stay with me, because the name count is only the beginning. Moskowitz walked the committee through a timeline so sequential and so documented that dismissing it requires not looking at it. 12 months ago, Republican influencers were given Part 1 of the Epstein files, not Congress, not the public, influencers. Bondi said the full list was on her desk. A DOJ memo surfaced saying there was no list. Phase 2 never came. The president called Epstein a hoax and attacked his own base for wanting the files. Republicans on the Rules Committee voted against releasing them, then refused to return until they were protected from future votes. Then Todd Blanche, the Deputy Attorney General, and before that, Trump's personal defense attorney, was sent for a 2-day private interview with Ghislaine Maxwell. Days after that meeting, Maxwell was transferred to a minimum security facility in Texas she was ineligible for under federal regulations. Inmates call it Club Fed. The Wall Street Journal leaks stopped. When Massey filed a discharge petition to force the files out, the White House called it a hostile act. According to Republican members who signed it, they were brought into the Situation Room and offered appropriations deals or threatened with primary challenges. It didn't work. 218 signatures. The full House, except one member, and the entire Senate voted for release. The president signed it only because the veto math was impossible, and still, half the documents required by law have not been released. According to unverified accounts circulating among investigators familiar with the withheld material, the unreleased portion contains documentation of financial transactions between Epstein-linked entities and individuals currently serving in senior government positions. The specific figures allegedly involved, if accurate, would represent one of the largest undisclosed conflicts of interest in the history of federal appointments. These claims are unverified, but they are, sources suggest, the The reason the Situation Room was used to pressure Republican signatories rather than a standard meeting room. You don't use the Situation Room to discuss a congressional petition unless what's inside those files is genuinely dangerous to the people in the room. Howard Lutnick told a committee that in 2008 he visited Epstein's home, saw a massage table in the living room, heard Epstein describe it as the right kind of massage, and left with his wife. He then added, in his own words, that he was certain the Epstein material was all on video because Epstein was the greatest blackmailer of all time. The question Moskowitz posed is the only reasonable one. How would Lutnick know that? What specific knowledge leads someone to describe a convicted sex offender as the greatest blackmailer of all time with that particular certainty? Lutnick is now the Secretary of Commerce. According to the files, he and his family were on Epstein's Island in 2012, 4 years after Epstein had already pled guilty to state charges. The Department of Justice has not questioned him. When Bondi was asked whether the DOJ had spoken to Lutnick or to Felon or to Feinberg, all senior officials, all named in the files, she said she did not know, or that she was stunned by the question. The answers varied. The result was always the same. The redaction Moskowitz identified cuts deepest. He produced a document titled Epstein Victim List, 32 names, 31 visible, 1 hidden. The stated purpose of federal redaction is to protect sensitive information, the privacy of innocent victims. Sex trafficking survivors are among the most protected categories in the entire federal system. Their identities are supposed to be shielded by law, and yet 31 of them are visible on that list, while 1 other name remains covered. According to unverified accounts among committee observers, the redacted name belongs to an individual who has communicated directly with White House staff within the past 6 months. That has not been confirmed. What is confirmed is that the Department of Justice made a deliberate choice about which name on a trafficking list needed protection. It was not the victims. When Moskowitz asked the survivors in the room to stand and then asked if the DOJ had reached out to them, they indicated it had not. When he asked if they had been ignored after reaching out themselves, they indicated they had. Bondi did not turn around. She did not acknowledge them. She waited for the clock to expire and went back to her immigration photographs. The burn book moment, stripped of theater, is a confession. An attorney general who arrives at a hearing about child sex trafficking carrying a personal research file on the congressman asking questions, who waves it at him, invites him to pick a hit, has made a decision. The decision is that oversight is a threat to be neutralized. That decision, made in front of survivors who flew to Washington to watch their government account for what happened to them, is the final answer to every question about what the Department of Justice's priorities actually are. The documents exist. The names are in them. The redactions are choices made by people with names and offices. The Situation Room was used to protect something. The transfer papers were signed by someone. The 2-day meeting happened and the leaks stopped. None of that is speculation. All of it is in the record. And the people who brought a burn book instead of answers are counting on you to find something else to pay attention to. Don't.